Hello guys, take a look at this. Ripple versus SE case gets unexpected extension. In a move that was completely unexpected, the Securities and Exchange Commission actually requested an order ordering Ripple to disclose its financial statements for the years 2023-24. This unexpected turn of events occurred in the legal battle that Ripple was engaged in with the SEC. The request, which was submitted the day before, adds an additional layer of intricacy to a case that was already quite complicated. Both parties had reached an agreement on a joint briefing timetable for remedies in the aftermath of the verdict that was handed down on July 13th. The ruling stated that XRP itself does not qualify as a security, but that specific Ripple sales that were done under written contracts do constitute as securities. For the purpose of completing the discovery process pertaining to remedies, the court had established a deadline of February 12, 2024. In a recent turn of events, the Securities and Exchange Commission submitted a motion with the intention of compelling Ripple to reveal the total amount of XRP institutional sales proceeds that it obtained subsequent to the filing of the complaint for contracts that were entered into prior to the filing thereof. Ripple is accused by the regulator of continuously selling XRP as unregistered securities while simultaneously amassing billions of dollars in profit. Ripple XRP versus the SEC matchup. Ripple has been ordered to produce its financial accounts for the years 2022-23 and its post-complaint contracts that regulate institutional sales, according to the statements made by the SEC. Ripple appears to be unfazed and has stated that it intends to continue selling XRP to buyers who are institutional sales under the umbrella of Odell transactions. Ripple contends that it is able to structure future transactions in a manner that is in accordance with federal securities rules, hence questioning the requirement of an injunction as stated in the motion submitted by the regulator. Ripple submitted a motion for extension of time in response to the demands made by the SEC. The motion requested that Ripple be given a further 2 days until January 19 to develop its answer. As the case takes an unexpected turn, there are no indications that the legal dispute that has been going on for 3 years will be resolved. The most recent extension suggests that the drama in the courts is not even close to being over, and both Ripple and the SEC are getting ready for another round of legal maneuvers in this high-stakes struggle. A serious legal challenge is now being brought against Ripple by the United States Securities and Exchange Commission. Ripple is a leading player in the cryptocurrency market. In a recent turn of events, the Securities and Exchange Commission submitted a request to the United States District Court for the Southern District of New York, appealing for an order that would require Ripple to prepare comprehensive financial statements for the years 2022 and 2023. The Securities and Exchange Commission has been taking enforcement action against Ripple for some time now, beginning with a lawsuit that was filed in December of 2020. A motion of the SEC for the production of documents. Following the filing of the lawsuit, the Securities and Exchange Commission has made a request that explicitly targets Ripple's financial statements and contracts connected to institutional sales. In a verdict that was handed down in July 2023, it was decided that XR tokens that are sold to institutional investors are considered to be securities. This ruling serves as the basis for the motion. The SEC contends that these records are essential in order to provide Judge Torres with the information. He needs to make educated decisions on the possibility of injunctions and civil fines being imposed against Ripple. This distinction is extremely important for the SEC's case. When determining the proper legal remedies, the Securities and Exchange Commission emphasized the significance of these papers in their submission. This involves calculating the extent of any civil penalties that may be imposed on Ripple, as well as considering whether or not the company should be subject to injunction. The Securities and Exchange Commission is making this request as a strategic maneuver to improve its position in the ongoing dispute. The history of the legal battle between Ripple and the SEC in December of 2020, the Securities and Exchange Commission (SEC) initiated legal proceedings against Ripple, the company's CEO Brad Garlinghouse, and Executive Chair Chris Larsen. This marked the beginning of the legal struggle between Ripple and the SEC. It was alleged by the SEC that they had raised money by selling securities that were not registered with the SEC. In a substantial turn of events, the Securities and Exchange Commission made the decision in October 2023 to withdraw its case against Garlinghouse and Larsen, while it continued its legal chase against Ripple. The Securities and Exchange Commission is taking a broader regulatory action against many firms in the cryptocurrency sector, including major exchanges in the United States such as Coinbase and Binance. And this complaint is a part of that activity. The strong position taken by the Commission has been condemned by industry executives. Stuart Alderody, the chief legal officer of Ripple, has referred to the Securities and Exchange Commission as a out-of-control regulator due to the nature of its approach to the regulation of cryptocurrencies. The forthcoming Ripple trial and its implications for the industry in April. Ripple is scheduled to begin its trial, and the verdict may have enormous repercussions for the cryptocurrency sector as a whole. In the United States, the regulatory environment around digital assets is measured by the enforcement actions taken by the Securities and Exchange Commission, SEC. As a result, the Ripple case is being actively monitored by both investors and market participants in the industry. Ripple and the Securities and Exchange Commission are currently engaged in a legal battle that shows the complexity and ever-changing nature of cryptocurrency regulation. In addition, it highlights the difficulties that regulators encounter when attempting to apply traditional securities regulations to the dynamic and fast-changing world of digital assets. It is anticipated that the eventual verdict in this case would establish a precedent for the manner in which cryptocurrencies are handled in accordance with the securities law of the United States, which has the potential to influence the future of the cryptocurrency business in the United States and worldwide. Ripple is once again involved in a legal conflict with the Securities and Exchange Commission, SEC, which stands out as a significant event in the realm of cryptocurrency law. As part of its ongoing legal proceedings against Ripple, the Securities and Exchange Commission, SEC, has submitted a motion to force the business to disclose financial accounts for the years 2022 and 2023, as well as post-complaint contracts pertaining to institutional sales. The Securities and Exchange Commission seconded this action on January 11 in an effort to get essential financial information and sales contracts from Ripple. In response to a decision made by Judge Annalisa Torres, the request was delivered to Magistrate Judge Sarah Netburn of the Southern District of New York in the verdict that she handed down on July 13, 2023. Judge Torres determined that Ripple had violated securities regulations by selling XRP to institutional buyers and other individuals without first registering the transaction. According to the judge, Ripple's transactions involving around $729 million worth of XRP were not judged to be transactions involving commodities or currencies. Predictions for the price of XRP repeat from 2024 to 2031. Will the price of XRP reach 10x soon? Due to the fact that Ripple and the CS have not yet come to an agreement over the most recent document request, the court has provided both parties with 1 month after the discovery deadline to submit their respective arguments. The occurrence of this event gives rise to conjecture over the possibility of a settlement which has the potential to severely impact Ripple's trajectory within the cryptocurrency sector. JP Morgan executives make contradictory statements regarding cryptocurrency. A XRP attorney cites the unreversed decisions made by Judge Torres as evidence that Ripple's legal path has been strengthened. Ripple's defiance is met with a fiery response from the SEC in the ongoing battle over XRP.